Well, welcome everybody. I'm the last, you'll be pleased to know, or what have you. We've got some handouts, Joey and Mia, who help. Could you sort of just start handing those out there? We've got, one of the things I want to talk about is a digest we've done of the work we did in 2013. I'm going to be referring to that, and we've got some copies, so they're going to just distribute a few because I'll be referring to that. You may have picked them up from our stand, but if you didn't, there it goes. What I first of all like to do is to thank David and Cerebra for the sort of, I think it's been a fascinating event and really interesting contributions, and I know the sort of Cerebra events team have worked really hard, and so I just think it's been a great day. And what I'm going to talk about briefly is the new program that Cerebra has funded us in Cardiff to do, which is a new research program looking at problem solving. It's fairly unusual. I think Cerebra has not funded a law school to do research before. And it's really exciting well, it's something that we're really enjoying doing. So briefly going through this is a legal entitlement research program. What happens is that commonly, we're looking at commonly occurring problems in social care, health care, and education that families have, although at the moment we're not dealing with pure statements of special education need or plans. And people who've got those difficulties will refer it to the really excellent Cerebra team, who then filter these to see whether they're appropriate. Those are then referred to the university, what we would call pro bono, which is just fancy word for free, which lawyers do, a bit of free work. So and we've got we're a very large law school there. We've got tremendous undergraduate, postgraduate students who are interested in doing this sort of clinical work. They then get one of these cases to look at. It's coordinated by Hannah Walsh, who's the sort of the not the evil genius, but the incredibly capable genius there. And working with legal firms, Owen Mitchell, Foot Anstey, other really great firms, and barristers' firms, they then prepare advices and opinions, and they draft materials. It complements the guides and the precedents. The research team at Cerebra have produced, Tracy Elliott's sort of team has produced some really brilliant guides on transition. So we have a lot of questions today about what do you do with transition. Well, you go to a Cerebra guide that's been commissioned on transitions, which is a step-by-step guide about how you practically negotiate that very common problem of moving between services. Cerebra's also commissioned some really excellent precedent letters. So this is the letter that you draft when you've got this commonly occurring problem. This is the letter that you do, and all of those are on their sites. I suppose the thing that I'm most interested in is what do you do if those things aren't terribly accessible? It's what I often say is what happens if your sister isn't a barrister? Because that's something that's come up, I think, a lot today. I mean, Janet and Claire were talking about the high incidence of let's call it poverty amongst people with disabilities. And they may not have the abilities, they may not have the energy, they may not have the temerity, basically, to write a letter or to be able to adapt to precedent. And the idea is that you'd use law students who would do that for them and help them make those complaints. Because I think it's a huge barrier to making complaints. Many people are just frightened of doing that. So that's the process. And I've been struck by the themes today. I mean, Cerebra is unusual. It is got this sort of knowledge cycle that David was talking about, this research cycle. So you'll do research, but you'd use it for practical effect to help parents. Richard was talking about the fact that the parents don't really differentiate between specialist health stuff and just other services like respite care, like having a night's sleep, like having a piece of social care equipment. And I think that Chris it was very interesting. He was talking about the way you deal with challenging behaviour requires you to understand the nature of the disability, that there are different types of learning disability, different genetic issues, and if you adopt the same response to all of these, then it's not going to work. You're going to be more targeted, and in a way that's what we're doing in the law school. We're trying to find out the different types of commonly occurring problem and say, well, this problem, this is the legal response, but that problem you'd have a completely different legal response. And hopefully I'll quickly do this. And Alison was saying, I mean, the way to solve a legal problem, a social care problem, is dead easy. And that's to create a crisis. I had a client, and she went to a local authority meeting because they were absolutely doing nothing, and she just left her child in the council meeting and said, he's yours. And afterwards, the local authority said to her, look, that's not the way you access services. And she was saying, well, I'm sorry, that is actually the only way these days you access services, is by creating a crisis. But most parents, are not going to do that. And they do access services, as Alison was really saying, only when they can't avert that crisis, when it really sort of washes over them. So what we wanted to try and do was to find a way that you could solve some of these problems without creating a crisis and without going to these non-existent legal aid lawyers. So we have our wonderful students there working on these issues, giving up quite a lot of time each week doing this. We've got lots of very good laws that deal with this. Yes, they might be slightly complicated, but we've got a whole tranche of laws, which I list there in a way, that give people legally enforceable rights to respite care. Respite care is not a discretion, it's a duty. Once a local authority has decided you need it, it's got to do it. There's equipment there, there's rights of children, and we've got these new acts coming along. The Care Act comes into force April next year, and the Welsh equivalent comes in April 2016, and the Children and Families Act, part of it's already come into force. So we've got very good legal entitlements to these, but people have great difficulty accessing those. And that's the idea behind the Act, behind the work. And so what we're trying to do is to sort of categorize different types of problem, because they're not all about money. The inter-authority dispute is, well, everybody accepts that this is needed, and we heard when the Ombudsman Chief Executive talking about this, but you've got an argument about whether health fund, Maggie was talking about whether you fund the speech and language therapy, whether that's social services or health, and you've got this, what I would call Tweedledum sort of Tweedledee issue. We've heard about inflexibility. Somebody today was talking about the fact that you only get 6 services or something from the NHS, or we only do this during working hours, or you're only allowed 4 continence pads a day. Those sort of issues. They're incredible inflexibilities. Who says? Legally, you're entitled to a reasonable amount, and they've got to be a reasonable quality. You can't, you just don't have to put up with those sort of statements. So often, the legal response there would be saying, well, that's very interesting. Show us the piece of law that says you're only allowed 4 a day or whatever. You've got the further up the line problem where the person you're dealing with is reasonable, but there's somebody further up, which I would always... There's the too difficult to think about problem, which I'll come back to. Sometimes you've got a problem where everybody agrees, but nobody knows where the button is that you press that says yes. You have the personality problem. You have the sort of, we've all met people like that in organisations who you can't get past. And then we've got probably the most difficult, where they're just highly contested fact problems. The too difficult to think about problem, just to give you some examples of the way we're looking at this, if something's too difficult, it's often because the social worker, the health professional, the education just hasn't got time, or they haven't got the experience to deal with it. They've got massive caseloads at the moment, and we've got to sort of accept that that's the reality. It's what as a legal aid lawyer, is the sort of file that is on the edge of your desk. It's always there, and you're always about to get to it, but it's just too difficult to think about, really. So it's delayed. And of course, the solution with that is for us to say, well, this is the solution. Not to threaten to sue them or to complain, just to say, look, this is the problem, this is what you do. And by the way, this council did that and it worked. So you legitimate it by some benchmarking. So you can solve the, you can tell people how to actually get themselves out of a particular problem. You've got the interagency problem, which we've heard of lots today, where you've got sort of Tweedledum and Tweedledee, and you know, who is it? Is it the NHS, or is it social services, or is it the education or the NHS? And you have, I mean, I've had a case where we almost went to judicial review over a hoist, and not a hoist, a walking frame for a child, because it broke whilst the child was in an out-of-county school, and was it the health authority A or health authority B? And I think a walking frame costs about £400, you know. Judicial review costs about £15,000 if you're lucky. But it's this inability, and of course we have a particularly interesting way of solving those particular problems too. And you have it over ordinary residence issues with local authorities. So we have lots of different approaches to solving those different things. They each need a different response, which I think what was Chris was saying about the way what you've got to identify the type of learning disability before you identify the response. So there's many themes in the work that Cerebra are funding, the research work, which go across from health to social care, even to the law. Now we've got this digest, and I'm just really going to finish looking at this, and some of you will have had it. It's on the internet. This is only for 2013 because that was a pilot year. The actual research program that Cerebra is supporting at Cardiff started this year, but we'd had a pilot last year, and we produced a report of about 7 of these. They are Ron's stories, Alice's story, Harry's story, Ginny's stories, Neville's stories. These are all characters from Harry Potter. We haven't got Voldemort's story yet, but we're going to obviously have that fairly soon. I didn't think of this. And they're just sort of, what happens is the students briefly anonymise the facts, say this is what the law is, and then they look at the solution, what the legal position is, and they're fairly commonly occurring problems. So the first one is about direct payments, saying you can't have direct payments because you're ADHD and you don't get those. That's not a disability, which is... There's a word that rhymes with rollicks. You know, it's just saying in legal language that doesn't work. Then there's a refusal to do carers assessments, delaying carers assessments. Big issue, particularly young carers assessments, because often there's a sibling that's not being very well treated either if a child's got quite challenging behaviour, and very common problem. There's a school transport issues, which I'm going to come back to and finish on. There's continence services. I mean, a local authority, a health board said, we'll only do continence services, it'll only be this much, and you've got to do the assessment this way, which is going to be very difficult because the child would have been very embarrassed by the whole process. And inflexibility is something that happens a lot. You've got to do it this way, and of course we then write and say, well, that's terribly interesting. Who says you've got to do it this way? You know, you're a public authority, should act reasonably. A reasonable authority wouldn't do that. It would have a flexible service. Are you telling us that you've got no choice over when the assessment's done, whether it's done in term time or holiday time, whether you can only have 4 continence pads? Well, it doesn't, you know, don't see that anywhere in the law. And of course, then they back down on that one. And of course, we can then use this to say, well, actually, there's probably 252 other clinical commissioning groups doing exactly the same thing. So we'll change that. And one on the issue, I think, is the biggest national scandal, which is CAMS. So we've got quite a lot of concerning the children adolescent mental health services, which are inflexible, irresponsive, and just quite the most disgraceful children's issue, I think, that we have. But the one I was interested in, and I'll finish on really looking at this one, is this one. This is a case where, I'll remind myself, this is, I think, Harry's story. So this is Harry on page 8. And it's a school transport case. This is a young man, I think he's only 8, I may have got it wrong, and he lives within 3 miles of his local school. If you live within 3 miles of your local school, then generally the law says that the local authority doesn't have to provide you with transport, generally. Gandhi, in his autobiography, Gandhi, as you probably know, before becoming a troublemaker, was a barrister, a South African barrister for a long time. And Gandhi, in his autobiography, says, if you look after the facts, the law will look after itself. And I often teach students that, particularly barristers, that, you know, when you're in court, if the facts are strong, concentrate on the facts, and the law will sort itself out. But in a way, this case doesn't... I mean, what Gandhi was saying was actually more complicated than that, because if the facts are strong, it's still not good enough. You need a bit of law. In this case, the parents had done fantastic work. They had shown that it was completely unrealistic for this 8-year-old child with Down syndrome to go to school along the route, because it was a country lane, it was full of potholes. It was dark at night, and this child actually had obsessive behaviour about potholes and things like this. And it was completely unsafe. And they had done all the work, they'd done incredible photographs and diagrams and everything. They'd given it to the local authority. And the local authority had just said, no, we're not going to fund that. It's under 3 miles. Now, there's a lot of law there, and you'll see in there's a lot of law, and as Polly's already said, one of the really powerful pieces of law is discrimination law, the Equality Act. Because if you have a flat rate rule that applies to all children under 3 miles, then that can be discriminatory against disabled children, because if you apply the same rule to all people, then non-disabled children might be fine on that, but disabled children would not be. So it's what's called indirect discrimination. So the students did a brilliant opinion, but it was really on the shoulders, on the back of an incredibly overpowering, strong factual case. And the local authority completely changed its mind and said they would fund it. And I suppose the interesting thing for the research is why, having seen a completely compelling case, does a letter with a bit of law in it, Section 21 of the Equality Act and bits like that, suddenly change things? I don't know, really. Is it we've shown them the instruments of torture, basically, saying, look, if you don't agree to this, we'll go to one of these lawyers, Owen, Mitchell, Footansty, one of these barristers. Is that it? Or is it a sudden light bulb, you know? Oh, gosh, you know. I often think it's like the sun god Ra walking in, really, you know, and suddenly light is there. What is it that simple little letter changes something when the local authority is aware of, or the health authority or the education body is aware of these issues? Or does it just give a frontline worker the permission to go to a senior officer saying, well, I think we've got to do it because the law says this? And so I think that's really what we're going to do. We're going to develop these procedures to say, once you've identified what the problem is, then you'll use this particular technique. You'll obviously try and build on those facts. And there's a lovely picture we've got on there. There is Harry on his school bus the first day, you know, once the local authorities changed his mind with his toys there, you know. And so it's not only a very interesting piece of research, it's also, as David has said, it's actually informing and helping parents as well. And the sort of questions that we're going to be looking at is, in this case, what was the problem with the public authority doing it? Because it's not a big deal giving them a bit of support on a school bus. It's not a lot of money. What was it about the letter that resolved the problem, and what does it tell us about the particular category of problems? And so we'll then have all this material up on the Cerebra website, which people can access. The idea is that we will then try and get as many other universities in England, Wales, Scotland, Northern Ireland doing this, so that people don't have to go to Cardiff. They'll be able to go to London or Nottingham or whatever, because most of the universities now are developing these pro bono clinics because students are keen on doing it. And just so, I want to say some thanks to anybody, and I didn't spell research right. But you can see I was doing this rather quickly. Thanks very much. Thank you.